Now, you know, the Innocence Project out of Cardozo University, which looks at DNA evidence, which proves people to have actually not been guilty of the crime that they were found guilty of.
Yes.
They said that about 10% of the cases where, again, this DNA evidence proved that they were not, in fact, guilty of the crime that they were serving a sentence for, those defendants pled guilty. Now, is that because of this stacked deck? Is that because people don't want to deal with the fact that federal government has them outgunned? They get paid whether they get a conviction or not. They get to show up. They have an information advantage. I mean, is that why we're seeing people plead guilty who we know in some cases were in fact innocent?
Well, you know, you need to step back from the Innocence Project. I would imagine if you look at most of those cases, you're going to be looking at state cases and not federal cases. And with the state, a lot of times a defendant may take a plea for a lot of reasons other than the ones you find with those facing federal charges. I mean, DNA does come into play with a lot of federal charges, but not as frequently as they do at the state. And a lot of times, you know, keep in mind when you're looking at these defendants, they don't know the system well. They are overwhelmed. A lot of them can't afford their attorneys, and you are appointed essentially a public defender who are excellent attorneys, but a lot of times they're overwhelmed. And when you're looking at plea agreements, for the most part with the government, it's about moving cases along. They don't, you know, they want the certainty of a conviction, but they really don't want to go through a trial. And it's not really that different than a defendant. He gets a deal. He may not believe that he has done anything that bad, but then again, he wants to make sure that he or she is not going to go to jail for some inordinate amount of time.
So, guys, just so we're not assuming anything here that the viewer might not fully be aware of, what we're talking about here is situations where a prosecutor could say to a defense attorney and his client, look, if you guys go ahead and strike a plea bargain here, we're going to give you a 5-year sentence. But if you push ahead and this goes to trial, we're going for the full boat. We're going to go for the 10-year sentence, and we're going for that hard. We promise you. Now, the Supreme Court case is the precedence, the holding in this concept of plea bargaining. It's a 1978 case. It's called Bordenkircher versus Hayes. But in that case, what they said is that it's patently unconstitutional to pursue a course of action whose objective is to penalize a person for giving up their constitutional rights, for giving up their right to a trial. Buck, you laid it out. The whole system is built around this concept of a right to a trial, to force the government to say, prove it, right? So if we're abrogating that right, the question becomes, is the government actually threatening you? Are they threatening you that if you don't give up your right to a trial, they're going to punish you with a harder and harder sentence? And that becomes a very, very difficult thing to analyze.
I would say yes, because when you look at, if you're looking at perhaps 6 months suspended sentence or 20 years in a federal penitentiary, which in some of these cases, the disparity is that much. It's because of these federal sentencing guidelines now. Politicians want to look tough on crime. They want to look tough on all crime, drugs, fraud, you name it. And so they stack up these sentences, and judges have less and less discretion in these. Now, Roscoe, I want to ask you, I mean, isn't that the case now where judges their hands are tied to some degree? If a case is brought and they're found guilty, and the defendant is found guilty of certain crimes, under statute, they're looking at some pretty hefty penalties, even for some things that years ago might not have been so severe. Isn't that the case?
Well, those are the federal guidelines you're talking about, and that is the case. The idea of the federal guidelines are to make like defendants sentenced in like ways, so that there is no, if you will, forum shopping. But, you know, keep in mind when you say that a judge has his or her hands tied, you know, the judge has a role in plea bargains and in trial. If a judge is listening to a case and it's going to trial and the evidence isn't there, the judge has a right to dismiss those charges. And once a jury's sworn, that's it. The government's done. And even if you have a defense attorney who is either unwilling or unable to ask the right questions, when a plea is taken, there is supposed to be a representation by the defendant of what happened. And if the judge doesn't believe there's a criminal case that is made out by the defendant, they're not supposed to take that plea. So there are protections. It's not as if the government has all the cards in this and really pushes this through.
Roscoe, this is Amy here. A really quick question for you. Buck mentioned Conrad Black, the conservative publisher, Scooter Libby, who worked for the Bush administration, and Senator Ted Stevens, a Republican. In your experience, when you're looking at these cases at the federal level, does it seem that they focus on people who are involved in politics in some way, and then what we're seeing is the criminalization of politics?
I don't know if focusing on them is really fair. There is little doubt that politicians get the publicity, but going after politicians is hardly new in this country. Bribes and the independent counsel's been in existence over the years, but going after governors, elected officials is not something that's new to this country. What is new is really the coverage. I think it's a good thing. You're talking about the First Amendment in action. I think we know a lot more than we would have known, say, 20 years ago, 50 years ago, or 100 years ago. So they take on a prominence that they may not have in the past. But it's really not new to this country that somebody who's been an elected official has been threatened with a jail sentence.
Ross.